Good morning. Welcome to the Supreme Court of the United Kingdom. Today is the second day of the appeal in the case of TN Vietnam against the Secretary of State for the Home Department. In a moment, we'll hear the submissions by Mr. Tan on behalf of the respondent, the Secretary of State. But before we hear Mr. Tan, I will remind the public and representatives of the media that reporting restrictions apply in this case. The court has ordered that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or of any member of her family in connection with these proceedings. Mr. Tam.
I'm grateful. May it please the court. Ms. Barnes and I represent the Secretary of State. And Ms. Anderson, who's also appearing, represents the Lord Chancellor. Can I just say a word about how we plan to do the submissions? The plan is for me to make submissions on behalf of the Secretary of State, and those submissions will be adopted by Ms. Anderson on behalf of the Lord Chancellor. We have a joint case filed with the court. What we will do is to consider, probably at the short adjournment, whether there's any need for the Lord Chancellor to make any separate submissions, or whether, as is much more likely, learned friend Ms. Anderson can simply adopt the submissions that I've made. And we hope that that will be an efficient use of the hearing time today. Can I also just start by giving the court a roadmap of the structure of my submissions? There'll really be four parts to this. First of all, I propose to make some introductory submissions that will include some explanation of the procedural position and how we've got to exactly where we've got to, because I apprehend that from some of the questions asked by the court yesterday that we probably need to make sure that that is all straight. The second part will be issue one. These will be the bulk of my submissions. Then I'll go on to issue two. Because that's really the flip side with corollary of issue one, my submissions there will be relatively short. And then finally, the fourth part will be to deal with issue three, the facts. And because of the conventional appellate approach to the factual part, again, this part of my submissions ought to be fairly short. So can I please start with introductory submissions and with 6 points to make about the procedural position. Those of us who've lived through this case probably don't want to remember too much about it, but we start, of course, with the position that it is accepted on all sides now that there was structural unfairness in the DA6 sense, because the Fast Track Rules 2005 were held to be ultra vires, and that is now no longer in dispute. That ruling was made in the JR proceedings before Mr. Justice Ousley, and he and the Court of Appeal then also went on to deal with the consequences of that structural unfairness. It is the appeal from the Court of Appeal in those proceedings which is before this court this week. So that's the first point. The second point is this, that regardless of the outcome of this week's appeal, it is accepted on all sides that there will be some cases in which the old appeal determination does need to be nullified. I use the word nullified because it avoids the technical language, but we do now know that it is quashed. But can I stick with nullified for the moment? The appeal determination will need to be nullified, and then further steps will follow. From the JR proceedings, or rather from the finding about the ultra vires of the fast track rules, the next logical question was which forum was the correct forum in which the old appeal determination should be nullified. At the time of the hearing before Mr. Justice Ousley, it was the assumption both of himself and of the Court of Appeal, of Lord Justice Underhill and the Court of Appeal at an earlier stage, that it should be the FTT. The reason for that was because the FTT had already indicated that it would exercise a set-aside power that it had under the 2014 rules to deal with 2014 rules cases. That is the order that was made in Alvey, to which reference has been made. So what happened was that after Mr. Justice Ousley's decision, TN and her co-claimant US applied to the FTT to set aside their appeal determinations, which of course were made under the 2005 rules, not the 2014 rules. The FTT considered this and concluded that actually it had no jurisdiction to set aside 2005 rules determinations, even though it could set aside 2014 rules determinations. So TN and US applied for JR of that FTT decision. That is the JR that was decided by the divisional court, constituted with the same constitution as decided the appeal from which this court is hearing an appeal. And that is the divisional court JR that is in Authorities tab 7, Authorities volume 7, tab 67 at EF 4475. There's no need to turn it up, that's just to give the court the note of that. The result of that is that if the old appeal determination needs to be nullified, we now know that it needs to be quashed by way of a JR application. The need for a JR application to quash that old appeal determination is why questions of time limits are also particularly relevant in this context. The argument yesterday focused on fairness or unfairness, but actually both Mr. Justice Ousley and the Court of Appeal also had things to say about whether or not time should be extended to bring what is inevitably a very old JR. So that is where, or that is the route by which we got to the divisional court determination made at the same time as the Court of Appeal decision in this case. The third point is that under the 2014 rules, as I've said, Alvey, the FTT and Alvey said that they do have a set-aside power. This was said yesterday on behalf of TN to be an arbitrary distinction, that those whose appeals were determined under the 2014 rules could simply apply to the FTT to have their determination set aside. But those whose appeal determinations were under the 2005 rules have to apply for JR. We respectfully disagree that that's in any way arbitrary. That is a consequence of the fact that there was a new procedural regime brought in 2014, and that procedural regime had a new set-aside power, but it applies only to 2014 rules cases. So there's nothing arbitrary in that. That happens when you get new procedural regimes. Can I then turn to a pair of points, so these points 4 and 5, about what happens in the various possible outcomes of this appeal? The first thing to say is that if TN is correct and this court allows her appeal, and there is automatic quashing subject only to the making of an application, then there is no need for anybody to consider whether there was individual case-specific unfairness in the old appeal determination. It just gets quashed, regardless of whether it was originally fairly determined or unfairly determined. So that's point 4. Point 5 is the flip side of that. If we are correct and the quashing is not automatic, and there must, as the Court of Appeal and Mr. Justice Ousley said, have been case-specific unfairness in the determination of the appeal, then a JR application must be made, and it is the JR court which will have to consider the question of whether there was unfairness in the individual case. Now, there are two potential consequences of that. If the JR court says, yes, there was unfairness and we should extend time, then what happens is that the original appeal, the 2005 rules appeal, revives upon that quashing. That old appeal the old appeal proceeding can then be continued in the FTT without there being any further consideration of whether the original determination was unfair. The JR court will have decided that. That means that any subsequent proceedings in the original round of that appeal, and for that matter, anything consequential, will all fall away. So, for example, if the claimant had originally appealed to the upper tribunal and been unsuccessful, then the upper tribunal's work will basically have completely redundant. It will be otiose at a stroke. Any removal directions that were set would have to fall away. Any judicial review challenges to those removal directions would also become completely academic. And also, and this is particularly notable in the context of these cases, both TN and US, if any fresh claim submissions have been made, and if any fresh claim decisions have been made, they would also inevitably, automatically become redundant as soon as the original appeal proceedings revive. Everything that happened would be overtaken by the very late quashing of a very old appeal determination. If, on the other hand, in the JR proceedings, the appeal determination is not quashed, then the position is simply that the original appeal proceedings remain determined as they were. But that doesn't shut out the claimant from pursuing all the other remedies that are available, including, notably, being able to make a fresh claim if there is new material on which they wish to base such a claim. And then if they have made a fresh claim, then of course, if that's refused, there will be a new right of appeal to the FTT, and then that will happen in the usual way. So those are the alternative consequences of the outcome of this appeal. The final procedural point is this. The FTT isn't a party to this JR. Now, there's been quite enough procedural complexity in this case as it is. It was correctly recognised by the Court of Appeal in PN Uganda for the court's note, that's Authorities Volume 6, Tab 63, EF 4377, and particular paragraph is paragraph 56 at EF 4388. The Court of Appeal correctly recognised that in strict theory, in this kind of JR, the FTT ought to be a defendant. It naturally follows it's the FTT's decision that is under challenge, and so the FTT should be the defendant to that challenge. And if the challenge to the FTT determination is brought in at a late stage, then strictly speaking, the FTT ought to be joined as a defendant. Now, in the present case, it didn't happen. We don't say that anything turns on that or there should be any consequences. It is a procedural irregularity. But because the FTT conventionally doesn't take any part, we don't say that anything needs to be done, and we don't go behind what has been done. But it is important to note that it isn't procedurally regular, and that is important when one comes to look at the issues, the central issue in the case, issue 1, because there is a real question about what the correct target is, and depending on the target, you identify the defendants that ought to be present in the proceedings. There are 3 further introductory points that I'd like to make. The first of these is the consequences. Before I carry on, I think Lord Briggs has a question.
Just before you do, Mr. Tan, the picture which you painted, and this assumes, without in any way deciding or suggesting that you're right on issue 1, that there would be JRs where the applicant was advancing reasons why the earlier appeal had been unfairly had an unfair outcome due to an inability to present evidence, which such further evidence has become available at the time was presented to the JR court, and it would presumably be very strongly overlapping with the evidence that would be presented to the FTT on a resumption of that earlier appeal. Is there any way, procedurally, in which the two can be rolled together, for example, by the judge who hears the JR application going on, if it's successful, immediately to hear that appeal, perhaps sitting for that purpose as a judge of the FTT?
My lord, I can see the attraction of that. I hesitate to give an answer because I don't know what technical steps might be needed for a judge of the High Court to sit as an FTT judge. It's not impossible, but I don't want to assume that it could be done automatically or without some real technical steps having to be taken. While it would be efficient for that to happen, the two courts, that's to say the JR court considering the quashing of the old determination and the FTT then hearing a merits appeal, are of course considering very different questions. So there would be there's an overlap of evidence, obviously, but whether it would save much time would be open to question. Also, it would mean that on a JR looking at the question of whether the original decision was fairly determined, it would require both the claimant and the Secretary of State inevitably to prepare for the full appeal as well as for the JR, and that might not actually be the most efficient use of preparation time. Lady Arthur had a question for me.
Yes, absolutely. In the case of the the cases where there's already been an appeal from the first tier to the upper tribunal, is it the Secretary of State's position that the Secretary of State is not going to argue that by the two processes together, procedural unfairness was in the event avoided or mitigated or removed? You know, in case of labour law and some other areas of law, you can put together the original appeal hearing and the appeal hearing and come to a conclusion about procedural fairness. But are you abandoning that possibility?
I'm not abandoning that possibility, but it's not a possibility that has been raised by either TN's case or, for that matter, US's case. I think that it would be a very case-specific question as to whether or not what happened in the upper tribunal had cured any unfairness in the FTT.
That's right.
So I don't want to be too ambitious in my submissions on that.
No, but for the purpose of keeping my note, I have to, as it were, make sure that you have reserved that as a possibility. I'm not giving any view about it, but that it's not been ruled out.
Lady, it's certainly not been ruled out, no.
Thank you.
I'm grateful. Can I then go to the three further introductory points? The first one considers the consequences of acceding to TN's argument. I should say at the outset that the submissions I make here are not in any way intended to make the court's flesh creep. They are simply the inevitable practical consequences of TN's argument being correct. The 2014 rules, as you know, the FTT has decided that it will set aside on application and those appeals will be reheard. They don't cause much of a problem because the 2014 rules were only in force for about 9 months. A relatively small number of appeals was heard, although it's a large enough number that it would cause some difficulty to the tribunal, as I understand it. It's not unmanageable. And of course, the rehearings would then take place, or probably would have taken place, relatively soon after the original hearing or the original appeal had been determined. In contrast, the 2005 rules were in force for almost a decade. The round number figure that is quoted for the number of fast-track appeals dealt with is about 10,000. Most of those were appeals that were dismissed, so there would be individuals who would be aggrieved. There are far, far greater practical consequences to finding that all of those appeals were automatically unfair and automatically quashable purely on application. We simply don't know how many cases might come out of the woodwork. To put it bluntly, it is true that some people will have moved on. Some people's appeals may simply be water under the bridge. For example, they may have had a fresh claim accepted and they have no need for an appeal now to be, or the original appeal now to be decided. Some people may simply have moved on in their lives, or they may have obtained leave through some other route. But that is not going to apply to everyone. And so there is the potential for a very significant number of cases to come out of the woodwork and to become a practical problem. Even removal overseas, we now know, is not going to mean that these cases can be disregarded, because it is precisely that case of PN Uganda which illustrates this. This is just for your notice, Authorities, Volume 6, Tab 63, EF 4377. The bare bones of the facts were that the claimant there was lawfully removed to Uganda in December 2013. She'd made 3 JRs challenging her removal. They were all dismissed, and then she was removed. And there's been no suggestion that the removal itself was unlawful. You can see that in the Court of Appeal paragraphs 20 to 25, starting at EF 4381. Eventually, she did not bring her 4th JR until October 2015. So that's almost 2 years after she'd actually returned to Uganda. You can see that fact at paragraph 36, EF 4384. And eventually, after the High Court's finding, PN returned to the UK some 5.5 years after she was removed, with her old appeal once more revived and yet to be dealt with. The date we think is probably about July 2019. You can get that from paragraph 43 at EF 4385. That also illustrates that when we say very old, they could be very old determinations. These might now go back to 2005. That's 15 years ago. And if TN is right, it means that any claimant from then could simply apply to the court for JR and have the old appeal determination set aside. If they're abroad, they may claim to be entitled to come back to the UK now and then restart the appeal proceedings all over again. This is a very significant consequence of the argument. We also point out that in present circumstances, it's entirely foreseeable that bodies representing the interests of asylum seekers would be likely to publicise such a result from this court, and they would be likely to encourage people to take up their established legal rights. I don't mean for a moment that they're not entitled to do that, or if this were the court's conclusion, that this wouldn't be an established legal right. But this would, as a matter of practice, enormously increase the likely scale of the problem. So those are practical consequences, which we respectfully say are important in considering the merits of TN's submissions. It's a facet of the rewriting of history that is always implicit in the quashing of a decision, thereby treating it as never having had any legal effect. That is the consequence. We also draw attention, I have mentioned this already briefly, but we also draw attention to the fact that this is when the application is made to quash the appeal determination, it is not just a question of showing unfairness, but there is a question of asking for an extension of time, possibly a very considerable extension of time, for bringing a JR to challenge the original appeal determination. TN's own judicial review application was way out of time. It was brought over a year, I think, after the original appeal determination, and it wasn't even actually until a long time after that any question arose of challenging the FTT determination itself. But there's a potential prospect now of people asking for a 15-year extension of time to bring this JR application. And there are real difficulties with that because a quashing undoes a lot of things which have become established events. So, as I've said, fresh claim decisions, possible upper tribunal proceedings, and so on and so forth. Now, these consequences are not impossible, And we know that where a determination does have to be quashed, for example, US or PN, then these consequences will inevitably follow. But these consequences are a reason that there should be careful judicial consideration of whether it is truly necessary to quash the original appeal determination, rather than turning that quashing into a simple automatic event on application. It may be necessary if it turns out that the original appeal determination was unfair, but we respectfully say it is not necessary to trigger all of those consequences if the original determination was actually fairly reached. I think the concluding aspect of this point is to mention that this is, of course, an aspect of finality in litigation, an aspect of legal certainty. Can I just give the court a couple of references to the importance of this? First of all, we have cited in our case Lord Justice Sheeman in Percy and Hall, its authorities, Volume 5, Tab 44, at EF 3818. The relevant page is EF 3845 at letters C to E. We've actually put the quotation into our case if that's a more convenient place to look for it. But the continuing importance of these principles has been very recently reiterated by this court in DN Rwanda. And you'll find that in Authorities Volume 1 at tab 6. It starts at EF 2313, but we draw attention, please, to paragraph 20, EF 2327, and paragraph 38, EF 2331. Respectively, they're in Lord Kerr's and Lord Carnwath's judgments on the case. And the final introductory point is this. It's important to remember that this challenge is a challenge which flows from the invalidity of the fast-track rules. And it is a challenge to the appeal determination. Much of the submissions made on behalf of TN, and indeed much of the intervener submissions, have been directed to the unfairness, they say, of the detained fast-track system as a whole. But it's important to remember that the rules, which form the basis of this present case, only govern the appeal stage. They did not govern whether or not somebody was to be placed in the fast track. They did not govern how the Secretary of State would deal with a person who was placed in the fast track while their claim was being administratively considered. And they only really bite when, or if and when, the asylum application is refused and the appeal and the individual decides to appeal. For this reason, the intervener submissions, we respectfully say, include two fundamental errors. First of all, the interveners are, we respectfully say, incorrect to say that the only basis on which people were allocated into the detained fast track was these rules, which have now been quashed. But the rules didn't affect this question at all. In fact, if you go into the history of the detained fast track, originally, the fast track didn't apply to the appeal stage at all. Can I just give you a reference for that? It's DA4. We haven't looked at that, but it's a decision of the Court of Appeal about the completeness of detention policy. But it does contain this particular paragraph that sets out the history. DA4 is at Authorities Volume 6, Tab 54, EF 4069. The relevant paragraph is 18 at EF 4077. And the other aspect in which the interveners are, we respectfully say, wrong is in answer to my Lady Arden's first question, which is, what do you do about the person who comes before the FTT and says, I've got everything I need, I don't need any more time, I'm ready to get on with my appeal, thank you. was that person's appeal also unfairly determined? Learned friend Ms. Kilroy's answer was that you have to look at the unfairness of allocating them into the detained fast track to begin with. But we respectfully say that must be wrong because the rules just didn't bite at that time. They had no application at that point in time. They only applied after the asylum claim had been considered and refused and a question of appeal arose. So hypothetically, if the Secretary of State decided the asylum claim in the claimant's favour, there would be no question of the rules having application. Or if the Secretary of State looked at the claim and said, this is too complex for the fast track, I'm now going to take it out, again, the rules would never bite. And so with respect, the answer given by the interveners to that is wrong. So those are the introductory points. Can I then please now turn to issue 1, which, as I say, will be the bulk of the submissions. I should start by saying, and genuinely saying, that we accept that fairness is important in this area. There's a wealth of dicta which would compel that on us, even if it wasn't willingly accepted. Especially in asylum appeals. It's important in all litigation, but especially in asylum appeals. We know all that, and the respondents do not dispute that. I think Osborne has been cited for this already, just so you can see what we do accept. We can see in Authorities Volume 1, Tab 9 at EF 2425, there is the passage from paragraph 66 to 71 at EF 2459 that explains that clearly and recently. And it is obviously important that any individual asylum appeal should be determined fairly. Can I also say at the outset, I now need, I think, to explain this in a little detail, but we accept, of course, that the principle of makes no difference is one that doesn't apply in England. That's to say, the proposition that if something is unfair, but it made no difference to the outcome, then it's not unfair. That is not a proposition which has found favour in English law. The conventional view here is that it is irrelevant whether the unfairness complained of made any difference to the outcome of the appeal. There's plenty of authority for that. For example, there's the Brent case, Authorities Volume 7, Tab 71, EF 4595. The relevant passage is at EF 4647, starting at letter G and going on to letter G of the following page. There's also the famous dictum, of course, in John and Rees, which you have in Authorities Tab 5, Authorities Volume 5, Tab 38. That starts at EF 3644. The relevant passage is at EF 3701, letters C to E. That's very well known. I don't need to ask you to turn that up. So we don't dispute any of that. But what I do need to spend a little bit of time on is the fact that the recent decision of Pathan, and in particular the paragraphs which Learned Friend Lord Panic took you to yesterday, is actually all about this principle and reiterating that makes no difference is not something that English law recognises. Can I ask the court, please, to go to Authorities Volume 1, Tab 10, EF 2471. The passage that Learned Friend took you to starts at paragraph 131, but actually it might be easier if I ask you, please, to go to paragraph 143, which we have at EF 2516, just so that we can see in this rather complicated case exactly what the issues were. Paragraph 143 at the very bottom of this page, Lord Kerr and Lady Black added a postscript just to identify what it was that had been before this court. The issues that were in the case are actually those identified at subparagraphs 2 and 3. So subparagraph 2, the very last few words of this page. And if you go on to the next page, it was the identification that there was a duty on the Secretary of State to notify Mr. Patham promptly of the revocation of his sponsor's licence, it being procedurally unfair not to do so. So that's one aspect of the procedural unfairness in the case. The second issue you see summarised at subparagraph 3, which was whether there was a positive obligation on the Secretary of State then to give Mr. Patham a period of time following notification for him to make an alternative application for leave or otherwise react to the revocation of the sponsor's licence. Now, the issue in subparagraph 2 was decided in Mr. Patham's favour by at least 4 members of the court. And then the issue at subparagraph 3 decided against the claimant by 3 members of the court. So that's quite complex. So I thought it would be useful to show you what those issues were. And then the outcome of the case is what's recorded at subparagraph 1, going back to the bottom of 2516. Which is that the appeal must be allowed, and that was the decision of 4 members of the court, that should be the outcome of the case. Now, having done that, can I then please ask to go back to EF 2513? Because from the bottom of that page, paragraph 131 onwards, is the passage that contains the paragraphs that have been particularly drawn to attention. Without going through the paragraphs right at the moment, can I just ask you to skim through 131 through the whole of the next page? These are the paragraphs that we've already looked at. And then go to the paragraph 136, which is the top of 2515. And Lord Kerr and Lady Black say, we have concluded, therefore, that the failure to inform Mr. Patham promptly of the revocation of the licence constituted procedural unfairness. So this passage, 131 to 136, is all about the first issue, the prompt notification issue. If I can then go back to paragraph 131, you see that the second sentence refers to the duty to give notice being an accepted element of the duty to act fairly. And of course, the facts were that no notice was given. So here, there was right at the outset something that happened that was on its face unfair. What you then see in the following paragraphs is a discussion of what would have happened or what might have happened if that notice had been given. And the discussion is all about whether it would have made a difference if that unfairness had not occurred. So at the top of 2514, the last sentence of paragraph 131, it cannot be suggested that informing him promptly would not have made a difference. And then at 132 and 133, there are 2 options that are discussed that might have made a difference. At 134, there's another point being made, which is that you can't say that because ultimately he couldn't find another sponsor, Therefore, the unfairness of withholding the information was converted into fairness. And then finally at 135, there was the inevitable consequence of what happened, that the adverse consequences of becoming an overstayer were accelerated. So fairly read, this passage, we respectfully say, is all about where you start with something that is on its face unfair, whether makes no difference converts it into something that is not unfair. And it is unsurprising, given the strength of the authority about the makes no difference point, that the court concluded that makes no difference doesn't apply. The point, as I think that the court can see, is that all of this starts from the position that something happened which was on its face unfair. But that is not the issue in TN's case. The issue in TN's case is something different, which is, was there any unfairness? Did what happened amount to unfairness at all? Obviously, we accept that if it did, then makes no difference can't be advanced in English law. But that's a separate aspect for consideration.
Sorry, if I could just put some thoughts past you as to the structure that I think that you're putting forward, and that is that the case could potentially be analysed on the basis of whether TN had sufficient time to prepare her case, so that she was afforded a fair opportunity to be heard, which is a part of the rules of natural justice. Is that a correct method of approach?
Yes, it is, because the fairness of what the FTT did and how much time they allowed her to prepare her case, we will say, I think this is particularly relevant under issue 3, we will say goes to whether or not she was allowed enough time to prepare the case that she was then advancing to the FTT. And it is that question which has to be examined.
Right.
And this,
yes. Could I then just take it on slightly? If the essential question is whether or not she was afforded a fair opportunity to be heard, then potentially a negative answer to that question would be rendered more likely by the systemic failure of the procedural rules, and also by the requirement for a high degree of procedural fairness in relation to immigration decisions.
oh, my lord, yes, of course, I accept that where the required timescales are tight, somebody who has a complex or difficult case to present may more readily show that they've been denied the opportunity that they need to present their case. That is part of the context of all of this. But what we don't accept, first of all, the headline point, of course, we don't accept that in all cases there was unfairness, because there are plenty of cases where there was no unfairness. I'll come on to the authority on that in due course. But even where there is an issue about that, whether or not there was unfairness must be judged on the facts of every individual case.
Well, could I then take it on one stage further, and that is that if the argument that it's not automatic is correct, then she requires to set out in an affidavit. She has to address the case that she wished to have made, and she has to be believed in that assertion, so that the issue of credibility comes back in. So you would say,
yes, she should. I respectfully adopt that point. Yes, she should explain that. And one of the aspects of this case is that the case that TN is said, or it is said on TN's behalf, she wished to make, we are trying to piece together from evidence from other sources and not directly from her. But given that the indications have been given, we have answers to that. But yes, of course, we readily and respectfully adopt my Lord's point that ideally one should see the claimant himself, herself, saying, this is what I wanted to do, and this is why I was unfairly denied an opportunity to do it.
and if the individual then sets out their case, they would have to be believed in the assertions that they are making in that case. And so if, for instance, in this case, she had set out all the reasons, not in the abstract, but in the particular, she would have to, there would have to be, the Judicial Review Court would have to accept that those assertions were credible.
The Judicial Review Court would have to accept that she wished to advance that case. Yes, I don't go so far as to say that the Judicial Review Court must accept the truth of the new case she wants to advance. I think that would be going too far, but certainly she ought to be persuading the court that she genuinely wanted to advance this other case, and that she was prevented and unfairly prevented from doing so because of the time limits or the tribunal decision.
And so therefore the Judicial Review Court is addressing the question as to whether they believe that she wished to make that case and was prevented to do so because of the time limits, rather than belief in the case that she was making. The second question is not for the Judicial Review Court. The first question is that correct?
No, that's right. Yes, because I wouldn't want the Judicial Review Court to trespass into the FTT's field if ultimately there is another hearing of the appeal.
And to bring the application for judicial review, there may be necessity to apply for an extension of time. So the points that you are making about finality and social order would impact on the decision as to the extension of time, rather than impacting on this question as to whether or not she is believed in that she could have made a case if but only she was given additional time.
Well, these points all go to whether or not time should be extended to allow her to bring the claim. One of the points that we draw attention to is that the factors that Mr. Justice Ouseley and the Court of Appeal set out as needing consideration went both to fairness in the strict sense, but also to whether or not it was right that time should be extended, and inevitably time will have to be extended for all of these cases, given how late they now are. So they all feed into that, and they all feed into the exercise of the court's jurisdiction as to whether or not to extend time and allow a late challenge.
But then you don't, as I understand it, go on to a second question, and that is, if there was a failure to afford her a fair opportunity to be heard, you're not inviting us to say that it would have made no difference.
No, I feel constrained by English authority not to go that far.
And there are some cases that do go that far, but you're not going down that line.
I'm not going down that line today because I don't need to for the purposes of this case. There is a footnote that I will come to, but no, in my submissions I don't go that far.
Thank you very much indeed. Thank you.
Lady.
Thank you. It's a short question. You posed us the question, is there unfairness? But is the real question whether there was material unfairness? If you, for instance, go back to the facts of Cooper and Wandsworth, which are actually set out in para 33 of Pathan at 2483, then the information, what the homeowner wanted to do, and he was not given notice when he ought to have been given notice, was to put in information which might have caused the board not to demolish his house. And one's got there, of course, the seriousness of what the board were planning to do, plus the fact that there was some kind of link between what he wanted to do, put in that sort of information, and what the outcome was. So that could I just ask you, is it really a bold question? Is there unfairness? Or is there a more nuanced question of, is there unfairness which is material in the sense of that there is some link between that, potentially some link between that step and the outcome, potentially?
Lady, the short answer to that is yes. We're grateful for Lady's identification of that in that term, material unfairness, because we have said throughout that what the claimant needs to do is to show unfairness caused by the procedure that was causal of the, sorry, let me start that sentence again. That there was unfairness constituted by the rules, which was causal of the unfairness to her in the determination of her appeal. So causal unfairness and material unfairness, I think, really are the same concept. Obviously, if there's unfairness that was immaterial to the case, then on traditional judicial review principles, no relief would ever follow.
Thank you.
My lord.
I view that with my lady Arden as a spectrum, and that is there will be some facts which are central and important, which you have to have time to properly prepare in relation to, and there are some totally peripheral and completely irrelevant facts, which it makes absolutely no difference at all whether you have or haven't had time to prepare. So materiality is on a spectrum of decision making.
Lord, yes, and the materiality of a particular fact or a particular piece of evidence which the claimant says that she or he wished to adduce is something that the Judicial Review Court can consider when deciding whether or not to extend time to allow the old appeal determination to be quashed. I mean, just so that, I mean, obviously it's important to look at the whole spectrum, but it's important in TN's own case not to lose sight of what actually happened, which was that she lost an appeal on one basis. She was issued with removal directions. She judicially reviewed those removal directions and failed. She was then a year later issued with further removal directions. And then 2 days before her removal, she comes up with another and completely new claim and now says, well, I should have been allowed to advance that in my original appeal proceedings a year earlier. So this wasn't just a question of another piece of evidence. The question is whether the FTT was unfair not to have let her advance a claim on a completely different basis that she actually only advanced a year later. But I think I've trespassed a bit into issue 3. I will revert to that when the correct time comes. So makes no difference isn't part of English law. But as a footnote, we do note that something that we found when we were preparing this case, which is that the position in Australia is actually completely different. The relevant case, I don't need to ask you to turn it up, I'll just give you some paragraph numbers, but the relevant case is called SZMTA. Its authorities, volume 9, tab 86 at EF 5204. The context is that in Australia, they have retained a real distinction between jurisdictional error and non-jurisdictional error. You see that at paragraph 91 at EF 5224. All of the members of the High Court, sorry, I should have said High Court of Australia here, were agreed that makes no difference is part of Australian law. That is to say that if an unfairness has occurred, but it made no difference to the outcome, then you do not get judicial review relief. The difference between the majority and the minority was the legal route by which that happened. The majority said if the unfairness made no difference to the outcome, then you get no relief because the error was not jurisdictional error. You see that at paragraph 3 EF 5209, paragraph 38 EF 5214, and paragraph 45 at EF 5215. What the minority said was that a jurisdictional error is a jurisdictional error. But if it made no difference, if the unfairness made no difference to the outcome, then the court should refuse a judicial review remedy in its discretion, in its residual discretion. You get that from paragraph 78 to 79, EF 5221, paragraphs 84 to 85, EF 5222, and paragraph 90 at EF 5223. In this case, I don't need to go anywhere near trying to persuade this court to depart from established English authority and to take the Australian approach. This is all perhaps for another day if it ever becomes important. But it is interesting to see that a jurisdiction which is common law and closely aligned to ours has taken such a different view of this important topic. Can I then turn to the main part of this? Our main proposition is this, that there is a difference between what has been called systemic unfairness on the one side and what has more conventionally been referred to as unfairness, so that's to say unfairness in the individual case on the other. And the main problem with TN's claim is that it jumps from one side to the other. It aligns these two concepts in a way which does not recognize or respect the different aspects and the different lines of authority from which they come. The cases of systemic unfairness deal with a problem where a system poses a risk, and I emphasize that word risk, of unfairness in some, and I emphasize the word some, cases. And what you then get is a judicial review remedy that in effect requires that system to be modified and improved if it is to continue. But that kind of systemic unfairness is a completely different creature from the kind of conventional actual unfairness to an individual in an individual case. And we say that once you look at the authorities on systemic unfairness, you will see why it cannot be read across to the kind of individual unfairness, which is what TN is trying to establish. This case was, of course, built on its immediate predecessor, which was DA6. But what I would ask to do is to start from the beginning. And the beginning of this is really in the Refugee Legal Centre case, which is Authorities Volume 1, Tab 12 at EF 2601. Can I please ask to turn that up and to go to start at EF 2604, paragraph 6. This case, as I think the court knows, concerned an earlier version of the detained fast-track process. And the complaint being brought by the Refugee Legal Centre was that the timescales were too fast for individuals to have a fair chance to put their asylum claim. And what the Court of Appeal was doing here was, at paragraph 6, was trying to identify just what is the question that the court has to ask and answer in order to give relief in this kind of case. So paragraph 6, what is the question? And the RLC's submission there you see set out, advanced by Mr. Fordham as he then was, whether the system was capable of being operated, of operating fairly. But then 4 lines down on the next page, you see the Court of Appeal saying that a more appropriate question in our view is this: does the system provide a fair opportunity to asylum seekers to put their case? This avoids the arbitrariness inherent in the RLC's alternative approach of seeking to construct a typical case. So there's the identification of the question. And in answering that question, the Court of Appeal said this at paragraph 20, which is going on now to EF 2609. Under the heading conclusion, say the initial question, however, remains to be answered. Does the present system, considered in the round and at the point of entry, carry an unacceptable risk of unfairness to asylum seekers? Pausing there for a moment, you see that there the test involves risk of unfairness. It is clearly a different concept from it being unfair to everybody. They're looking at the question of risk. Going on to the next page, paragraph 23, you see the conclusion that the system was not inherently unfair. That's lines 3 and 4. And then at 25, having returned to the question of risk and indicated what they thought needs to be done to obviate it, they conclude, but like Mr. Justice Collins, we do not consider that the system itself is inherently unfair and therefore unlawful. On the contrary, so long as it operates flexibly, the system can operate without an unacceptable risk of unfairness. So this is where it really starts, and it's a risk-based approach. We also respectfully point out that right at the beginning here, the court was very alive to the difference between the question of a risk posed by a system and unfairness in any individual case. Can I go back to page 2605, that's EF 2605, and to paragraph 7. The court said, we accept that no system can be risk-free, but the risk of unfairness must be reduced to an acceptable minimum. This potential unfairness is susceptible to one of 2 forms of control which the law provides. One is access retrospectively to judicial review if due process has been violated. So that's clearly a reference to the conventional kind of case where an individual says, I have been treated unfairly. Retrospectively, I now want judicial review relief. The other, said the Court of Appeal, of which this case is put forward as an example, is appropriate relief following judicial intervention to obviate in advance a proven risk of injustice, which goes beyond aberrant interviews or decisions and inheres in the system itself. So that is the other kind of approach, which is exemplified by RLC, that is trying to correct risk in a system in advance and not tied to a specific case. You also see this distinction recognised at paragraph 24, EF 2610. Because there the Court of Appeal recorded that the RLC invited the court to find against the Home Secretary on essentially the same footing as this court did, upholding Mr. Justice Collins in Q. There, the essential finding was that the procedures applied to each of the applicants had been vitiated by unfairness to him or her. There is, however, a difference between that case and this. There, the deficiencies in due process identified by the court in its judgment had resulted in adverse decisions, which fell to be quashed in consequence. So pausing there, that's the retrospective individualized examination. Here, and that's to say in the RLC case, what has been identified is a gateway risk of injustice in the nature of things not case-specific, but caused by potential rigidity in a system which requires genuine flexibility. So there, the two approaches clearly identified right at the beginning of this line of authorities in RLC. Now, I promise I will come back to Q itself when I come to look at the other line of authority. But for the moment, can I say that there's that distinction between Q and RLC that is the key distinction that TN's argument with respect ignores. The RLC approach has been adopted in all of the cases in the line of authority that descends from it. Can I quickly, perhaps actually just give you paragraph references to the intermediate cases? Medical Justice, Authorities, Volume 6, Tab 61, EF 4324. The relevant paragraphs are 25 and 26 at EF 4335. There, the RLC test was applied. Then there was TABAC, Authorities, Volume 7, Tab 66, EF 4456. And the relevant paragraphs are 38, EF 4632, where they distilled the RLC test, and then 48 to 49 at EF 4471, where they applied that RLC test. And Howard League, Authorities, Volume 6, Tab 57, EF 4141, and at paragraph 48, which is EF 4150, they applied the RLC test. And then really the next stage is DA5 and DA6. DA5, Mr. Justice Nichols' decision, you have at Authorities 1, Tab 4. I don't think I need to turn that up because I can get everything from DA6 itself. This is Authorities Volume 1, Tab 5, EF 2298. Can I ask, please, to turn this up at starting at EF 2306, paragraph 22. You see there that RLC is cited, really the granddaddy of all of this. If you go on to paragraph 25 over the next page, you see TABAC also cited. Part of this line of authority. And then after discussion of the features of the 2014 rules, the conclusion that the court reached ultimately is summarized at paragraph 45. This is going on to EF 2311. The time limits are so tight as to make it impossible for there to be a fair hearing of appeals in a significant number of cases. The first three lines of paragraph 45. That is clearly a different way of putting the risk test on which all of this is based. if a significant number of cases will not have fair hearings, that is an unacceptable risk of unfairness. It is clearly a decision that is firmly in the same line of reasoning as all of those cases that follow from RLC. And we say that when one looks at all of this line of authority, it clearly means that the Court of Appeal in DA6 was not saying that no cases will have fair hearings. They didn't even necessarily mean that the majority of cases will not have fair hearings. On the basis of what they said, it is just, which is equally possible that they thought that perhaps even the majority of cases would have fair hearings, but it was an unacceptable minority of cases that would have unfair hearings. We just don't know. In DA6, the Court of Appeal didn't need to ask that question; they didn't need to answer it. So we don't know what would have been said. But it is clear that it is language that is inconsistent with the proposition that the Court of Appeal in DA6 thought that every case would be determined unfairly. And that is the conclusion which we respectfully say that Mr. Justice Ousley in our case and the Court of Appeal correctly picked up. Not all cases in the system will have been determined unfairly. Mr. Justice Ousley said this at paragraphs 80 to 82, that's EF 244. The Court of Appeal also picked this up, paragraphs 84 to 85, EF 208. And when you follow the whole line of authority, you can see that clearly they were right to do this. Can I, just before the break, refer to two other aspects? It's three cases. The first I can take together because the same approach has been taken. We've been dealing with procedure rules here, and the cases in this line have been dealing with that sort of procedure. But there is a line of cases dealing with court fees, and the court fees cases have taken the same risk-based approach. You will see this from the Hillingdon case. This is Authorities Volume 6, tab 55, EF 4099. If you go to paragraph 61, EF 4113, the terms being used are real risk and significant risk, that cases will not be brought and that people will, or children in that case, would not benefit from the court procedures. And the Unison case, Authorities Volume 7, tab 68, at EF 4489. If you go to paragraphs 87, EF 4522, and 91, EF 4523, you will again see the term real risk being used and the conclusion that a significant number of people found fees to be unaffordable. Not everybody, just a significant number. And in those fees cases, those tests, if satisfied and the other conditions satisfied, would have been enough to quash the fees cases. And then finally, on this topic, can I draw attention to the very recent decision of the Court of Appeal in FB Afghanistan? You have this in Authorities Volume 1, tab 7, at EF 2342. There were two cases here. One was brought by an NGO, Medical Justice again, and they made a systemic complaint about the removal window policy. And then FB himself brought a case-specific complaint seeking individual relief. You will see from paragraph 2 at EF 2344 what the case was about, the removal window policy, and the claim that it abrogated the right of access to justice because the notice given was too short to allow the instruction of lawyers to make representations. At paragraph 147, EF 2384, medical justice, you will see, succeeded because there was an unacceptable risk of interference with the right of access to a court. And the consequence at paragraph 165, EF 2387, was a declaration that the policy was unlawful. So that was the systemic challenge, all based on risk. In contrast, when the Court of Appeal looked at the individual case of FB, at 156 EF 2385, you'll see the finding that he was not in the event himself denied access to justice. And at paragraph 163 EF 2386, that therefore no relief specific to his case was required or appropriate. So a clearer distinction between the systemic complaint and the case-specific individual complaint you could not hope for. The Court of Appeal denied him case-specific relief. The only thing that FB got, you'll see at paragraph 166 EF 2387, was a declaration about the systemic problem. And that, we respectfully say, in a nutshell, illustrates exactly what the correct approach is. Systemically, yes, there is a problem, and the rules in this case were quashed or declared ultra vires because there was a risk. But it does not mean that every individual has suffered actual unfairness, and does not mean that every individual gets actual case-specific relief. My lords, my lady, would that be a convenient moment?
I think so. We'll take 5 minutes, Mr. Tam. Thank you very much. Mr. Tam.
May it please the court. Just before that short break, I had shown the court the line of cases on systemic unfairness, and drawing the distinction shown in some of those cases with individualized unfairness. I've already made the points that the language of these cases simply does not allow a reading that the courts concluded that every case was decided unfairly. Neither can we know in DA6 what proportion of cases were thought to have been decided unfairly. But what we can know from the language used is that the courts do not think that every case was determined unfairly, because that was simply not the question that is being asked or answered. And it doesn't have to be asked or answered, because the whole point of a systemic unfairness challenge is different. The consequence is that the system will be struck down, and then it will have to be redesigned if it's going to be continued. And we say that one of the features of these cases is that most of them have been brought by NGOs and not by individuals. So just going through the list: RLC, Medical Justice, twice now, Howard League, Detention Action, which has basically brought two rounds of proceedings culminating in those 6 judgments. They're not bringing their own specific cases. They are asking for the system as a whole to be looked at. And that just goes to show how different it is. But we say that there is one feature that just hammers this point home, and that is to look at the target of the judicial review claim that is being brought in these systemic claims. The target is the impugned legislation or the impugned system, either a complaint about the system as operated or about the procedural rules, or in the fees cases, the fees rules. They are the decision or action under challenge. And if the court grants any relief, it will be directed towards that decision or action. And notably, for example, in DA6, it would include quashing the procedure rules in question. The other category is different, not only because it's been recognised in those authorities as different, but even just thinking about the question of the target of the JR, it is different, because when an individual brings a case-specific JR, they are nominating as the target the case-specific decision or action that affects them. So, for example, in TN's case, it is not the procedure rules that are now in question. We've had that argument, and we did not appeal from Mr. Justice Ouseley on that. The appeal that's before the court concerns her challenge to the appeal determination itself. And the relief that's being sought is a quashing of that individual determination. It is the fact that it is a different challenge to a different target that leads to the courts applying a different approach. It is, as I've described it, the conventional case-specific approach to unfairness. And you can see this starting with the case of Q. I did promise I'd come back to it, and I'll show you now what that was all about. This is Authorities Volume 1, Tab 11 at EF 2544. The best place to start, I think, is paragraph 1 at EF 2561. This is decision of the Court of Appeal on appeal from Mr. Justice Collins. And I'm not going to read it all out, but you see, just skimming through paragraph 1, that halfway through the paragraph, this was about not supporting asylum seekers who did not make their claim as soon as reasonably practicable after they arrived in the United Kingdom. So that's just above letter E. And then the court went on, Mr. Justice Collins had before him claims for judicial review by 6 asylum seekers whose applications for support had been refused on the ground that they had failed to satisfy the Secretary of State that they had advanced their claims for asylum as soon as reasonably practicable. Mr. Justice Collins allowed those claims and quashed the decisions, that's the specific decisions in their cases, primarily on the ground that the procedure adopted in each case was not fair. And then it was the Secretary of State who appealed. Now, if you go to paragraph 69 at EF 2579, so at the bottom of this page, you will see under the heading, the principle of fairness, it's common ground that the burden of satisfying the Secretary of State is on the claimant. It is not, we think, in dispute that the burden of satisfying the Secretary of State, but the answers to the second and third questions posed above is also on the claimant. Further common ground that in deciding whether the claimant has so satisfied him, the Secretary of State must act fairly, which means both that he must set up a fair system to enable the decisions to be made, and that he must operate the system fairly, and then authority is cited for that. Starting at paragraph 74, EF 2581, the Court of Appeal set out a description of the system. I don't need to go through the detail of that, but I identify that here so that you can see what was in issue. And then starting at paragraph 85 on EF 2584, the Court of Appeal set out why it thought that the system was not fair. So in paragraph 85, and then you see that at 86 first, it seems to us, and then there's a long passage here going on to paragraph 100 that sets it all out. It's very usefully summarized on EF 2592 at paragraph 119, Roman 12. And there's a summary in 7 sub-paragraphs as to what the problems were. I'm not going to read that all out, but you can see from that. And then at Roman 13, you see the summary that the judge was right to hold that in each of the individual cases, the claimant had been treated unfairly initially, although there were case-specific wrinkles. And that is a summary of what the court had looked at in more detail at paragraphs 103 to 109, starting at EF 2587. I don't need to go to that for the detail, because you can see from the summary the nature of the consideration that had been given. It was on the facts of each case, and it included the factual wrinkles that are referred to in the last few words of Roman 13. For what it's worth, I should say that Mr. Justice Collins's findings on the facts are also annexed to the Court of Appeal's judgment starting at EF 2593. But again, I don't need to ask to turn that up. But you see that although the Court of Appeal had a lot to say about the fairness of the system, its actual decision was on a case-specific basis. Both Mr. Justice Collins's decision and the Court of Appeal's decisions were on case-specific grounds. They found that in each case there had actually been unfairness to the claimant. So the court in RLC, we say, were entirely correct to identify Q as a case of a different kind. It's of the case-specific kind. Similarly, if one looks at the case of Osborne, this is the parole board case. I won't need to turn that up now, but it's Authorities Volume 1, Tab 9 at EF 2425. If you look at the decision in paragraphs 98 to 100 on each of the three cases, this is EF, I'm sorry, we'll have to give you the EF reference for that. But it's paragraphs 98 to 100. There are the three specific cases looked at on their own facts. And the circumstances of each case meant that an oral hearing should have been held in order to be fair in that case. So this is plainly another case of individualized case-specific unfairness. There are also a number of cases cited by TN at paragraph 25 of her written case. Can I just go through those quickly? AF number 3, Authorities Volume 8, Tab 76 at EF 4729. If you look at the decision at paragraphs 63 and 65, EF 4815, you'll see that the actually very familiar proposition that there is unfairness if there is closed material that's not disclosed to the individual, and that non-disclosure denies the party knowledge of the essence of the case against him. But you can only resolve that question on a case-by-case basis. And that is indeed what is done in cases of that kind. What AF number 3 is not is a decision that merely because a closed material procedure results in someone else's hearing being unfair, that means that your own hearing is automatically considered unfair, even though you have been given the essence of the case against you. TN also cites Kanda, Malaysian case, Authorities Volume 5, Tab 39, EF 3707. At EF 3723, you will see that the unfairness was because of what was specifically done in that individual case. Unfortunately, there aren't marginal letters even in this report, but it's the paragraph in the middle of that page if and when you turn it up. Similarly, Barrow, which is Authorities Volume 7, Tab 70, EF 4562. If you look at EF 4592 between letters B and C, you'll see that unfairness was because of the circumstances of that case. I've already referred to Brent and John and Rees because those are really cited for the makes no difference point, but also they are actually case-specific cases themselves. The one exception in the authority that's cited by TN is Miller and Dixon, which is the Scottish temporary sheriff's case. This case is at Authorities Volume 5, Tab 42, EF 3770. Can I ask to turn this one up so that I can show you some passages from it? If you go to the head note, just for the context, you will see that the obligation coming into force on the 20th of May 1999 not to act incompatibly with the ECHR. And then on the 11th of November of that year, the High Court of Justiciary holding that temporary sheriffs did not constitute an independent and impartial tribunal and was therefore incompatible with Article 6.1 for proceedings to be before a temporary sheriff. And then everything stopped. But the question was about the cases decided between the 20th of May and the 11th of November. Paragraph 6, EF 3773, is the actual reference in the opinions to that decision that temporary sheriffs did not constitute an independent and impartial tribunal. But if you go on to paragraph 8, 3774, you will see that the quotation in the bracketed 3 sets this out. So also in the following paragraph, paragraph 9, the quotation with the bracketed 1, which is at the top, I think, of 3775, shows the basis of that case. And in paragraph 10, bracketed 3 and 4 of the quotation, you'll find that on page 3776. And the reason for drawing attention to that is to show that the defect in the independent and impartial tribunal was one that applied to every single case of its kind. Every single temporary sheriff failed that test. And that is why in Miller and Dixon, in the end, every case of its kind, let's say every case before a temporary sheriff, suffered from the defect. But that is an unusual case, because if you go back to the line of authority on systemic unfairness, starting with RLC, that is not the way in which our situation or comparable situations have been approached. It's been on the basis of risk. It's been on the basis that a number of cases, a significant number of cases, will be adversely affected. And that is why the system needs to be overhauled and improved. But Miller and Dixon is not authority for saying that you can just jump from that situation to saying that every case decided under these rules was decided unfairly or must be taken to have been decided unfairly. And that, we respectfully say, is the fatal flaw in TN's argument, it confuses these two different kinds of unfairness. She is seeking relief that would be appropriate if there were a case-specific finding of unfairness in her own case, but she claims that it should automatically follow from the very different kind of systemic unfairness that has been found in DA6 and then in her case on the 2005 rules. Milady.
I just wanted to make the point that there may be some kinds of procedural unfairness which become evident in the case of a systemic challenge, which mean that in fact every individual case will be affected. They'll be very exceptional, but one shouldn't rule that out. And likewise, there may be some reasons, some flaws in an individual case which are so contrary to the rule of law, like not having an independent judiciary, that one is bound to say that they're going to be the exceptions to the rule, and they must apply across the board. Would be wrong to think that that was so on your submission.
Milady, we certainly don't rule out the possibility of that kind of situation. So, for example, we have posited hypothetically a procedure, a court procedure, where one party is simply given no opportunity whatsoever to make any representations or submissions to the court. Now, yes, that would be very exceptional because it would be so obviously wrong given our traditions. But if that were to happen, then yes, I accept that in that kind of case, every affected person would be able to claim relief. But that is not the basis of the systemic unfairness that's present in this situation or in any comparable situation.
No, I wasn't suggesting it was your submission that it was in here, but I think Lord Wilberforce had something to say about this in a Privy Council case, commenting on John and Rees. Thank you.
I'm grateful. So we respectfully say that it would be quite inappropriate to accede to TN's submissions. It would be to fall into a legal error of confusing the two kinds of unfairness. And so TN's submissions and TN's argument should be roundly rejected. Indeed, just taking a step back, if TN were right and Mr. Justice Ouseley and the Court of Appeal were wrong, then the consequence would be that there would be many determinations of appeals that would have to be automatically quashed, even though they had been fairly determined, merely because there were some other appeals that had or might have been unfairly determined. Just on that broad basis, that is a consequence which we respectfully say is not required by principle, by logic, or by authority. Indeed, the authority spanning some now 16 years since RLC is all to the contrary. And the illogicality is particularly acute because actually the rules, although they had a tight timetable, they did allow a discretion in the tribunal to depart from those time limits in certain circumstances. And one of the things that might happen in individual cases is that they end up being determined fairly because the discretion in the rules themselves was actually exercised in their favour. So even though the rules are systemically ultra vires, an individual might actually have benefited from some of that. So all of this would be illogical, and we respectfully ask the court to follow and to endorse what Mr. Justice Ouseley and the Court of Appeal said. Can I, before leaving issue 1, make a couple of subsidiary, some submissions on a couple of subsidiary points? The first of these is about the second actor theory. Now, I could probably bore for England on the second actor theory. It crops up in quite a lot of cases. It cropped up in DN Rwanda as as my friend Lord Panic has mentioned. But actually, the second actor theory has nothing to do with this, and DN Rwanda, we respectfully say, just actually doesn't bear on the present case at all. The framework of DN Rwanda, I think, is probably familiar. There was a statutory instrument specifying serious offences that would, in the circumstances, permit deportation. Perhaps what I should do, sorry, is to give you the paragraph references as I go through this. DN Rwanda is Authorities Volume 1, Tab 6, EF 2313. The mention of the statutory instrument you see at paragraph 5, EF 2322. What happened in DN's case is that deportation action was taken and then he was detained pending deportation. That's paragraph 4 on the same page, 2322. And then a long time later, the SI was held to be ultra vires. And you see the reference in paragraph 9, EF 2323. The claim brought by DN Rwanda included damages for unlawful detention. You see that mentioned in paragraph 8, EF 2323. And lumber was rather inevitably cited. You see the reference paragraph 17, EF 2325. But the actual decision of this court was on the basis of a, quotes, more important, unquotes, reason. And that is exactly Lord Kerr's phrase. The statutory power allowing deportation, he said, was invalid. Detention was for the purposes of facilitating deportation. And without the existence of a deportation order, the occasion for detention would simply not arise. This is all found in paragraph 17 at the top of EF 2326. He expanded on that in the subsequent paragraphs 18 and 19. And also Lord Carnwath mentioned this and adopted this in paragraph 37, EF 2331. I'm skating through this quite fast, but the basic point is this, that DN Rwanda was in the end decided as a no power to detain case. You see that very clearly from what Lord Kerr said in paragraph 17. And that's why this and all the interesting discussion about DN Rwanda, the interesting discussion about the second actor theory in DN Rwanda and so on really has nothing whatsoever to do with the present case. And so we respectfully invite the court to set that on one side. It's not going to help here. I think that as a footnote, we say that even if the second actor theory was in play, there are three actors involved here. And we say that there clearly could be a case made that this is a second actor case. The other subsidiary point that I would make under issue 1 relates to successful appeals. We start at the outset by reiterating what we've put in our printed case. In practice, it is unlikely that the Secretary of State would seek to disturb an established immigration status that's been granted following an allowed appeal under the 2005 rules. So we're not talking about holding this out as an interorum argument. In practice, this is not going to happen. But we do say that when you're examining the legal logic of TN's argument, it is important to see the consequence of that as a matter of strict legal theory. After all, the tight timescales of the 2005 rules could, in theory, have affected the Secretary of State as well, because the Secretary of State was also going to have to get the appeal on in time. What the claimants have said is, well, actually, if the Secretary of State thought that she was hampered, she would take the case out of the fast track. And in practice, of course, we accept that that's likely to have been the case. But as a matter of strict legal theory, if you follow through the legal consequences of the argument, you can see that the Secretary of State could have been adversely affected. And if that's right, and then if TN's argument is correct, and there is automatic nullity, it therefore follows that the Secretary of State would, in theory, be entitled to apply to set aside an allowed appeal. Because if the appeal is automatically unfair and it only requires an application, then that must follow. The appellant, the claimant, could not resist the Secretary of State's argument by saying, well, actually, the Secretary of State didn't suffer any unfairness, or it would have made no difference to the outcome of the case, because it's a logical consequence of TN's argument on issue 1 that it's a nullity and it's a nullity. And so the Secretary of State would be entitled to have that set aside. And we also say, for reasons we set out in our printed case, that this is not a case where the principle in White applies. White is the authority.
Before you move on, Mr. Tennant, I think Lord Briggs has a question.
Before I make the point, perhaps my Lord Briggs, I think, has a question.
Well, Mr. Tennant, when in DA6 I was party to the Master of the Rolls decision, I thought we were saying that it wasn't that it was unfair in the abstract, but that it was unfair to appellants, not least because they, unlike the Secretary of State, were detained during the running of those short time periods. It wasn't a finding of unfairness in the abstract from which the Secretary of State could derive some incidental benefit by saying, well, sometimes it would be tough on us too. That simply wasn't investigated.
Lord, that's right, and that's why in practice we say that it's highly unlikely that we would take any of these points. But what I'm doing here is following through the strict legal logic of the argument that's being run, because it is an extreme argument that there is automatic nullity.
I see what you mean. Yes. Yes. Thank you.
Yeah. The final point I was just going to make was that White, Authorities Volume 8, Tab 80 at EF 4900, was a decision that a decision maker can't rely on its own unlawful act to found a criminal prosecution. Now, it doesn't take much persuading of the correctness of that proposition. But here, if the Secretary of State were in theory to do this, it wouldn't be the Secretary of State taking a criminal prosecution, but simply asking to set aside another decision maker's decision on the basis of, as I say, the strict legal logic of the automatic nullity argument. This is all an indication that actually the automatic nullity argument must be wrong. It has this consequence in this extreme circumstance, and that is an indication that it is wrong, even though in practice the situation would not be likely to arise. So, Lords and Lady, those are the submissions that I make in relation to issue 1. Would it be convenient then to turn to issue 2, which is the related issue of whether the Court of Appeal's approach was correct? Now, it's immediately obvious that in many ways this is simply the other side of the coin from issue 1, because it's a necessary part of our submissions that actually the Court of Appeal was correct to take the approach that it did for all the reasons we've given. It's not just the fairness in the strict sense, but also the extension of time and so on and so forth. So I'm not going to go through all of that again. What I think I can usefully do is to concentrate on, first of all, a few of the specific points made by the court, and then to respond to some of the points made by TN under this heading. So far as the factors mentioned by Mr. Justice Ousley in the Court of Appeal are concerned, we do stress that the Court of Appeal, both of them, both Mr. Justice Ousley and the Court of Appeal, were careful to note many things that have been prayed in aid by TN. So, for example, if you look at the Court of Appeal's judgment at paragraph 103, this is EF 212, they note that a high degree of fairness is required. and they note that there was an unacceptable risk of unfairness in a significant number of cases, and therefore it has to be borne in mind that when the JR court is considering whether to quash an old appeal determination, it must remember that the case that they have may be one of those cases. They specifically said that what they had set out, in particular at 104 EF 212, and what Mr. Justice Ouseley had set out at his paragraph 114 EF 255 was not a checklist. They are factors that they are to be considered. Ultimately, there was the one question to be asked, which was whether the appeal had been determined unfairly. And we respectfully say that if you just take a broad view of this, all of this is entirely conventional, it's entirely unexceptional, and it's entirely unremarkable. That if there is if you're going to look at whether or not an old appeal determination should be quashed, you look at all of these factors to see whether there was unfairness. It's also instructive, we say, to look at the actual outcome of the two cases before Mr. Justice Ouseley and the Court of Appeal. We had some procedural wrinkles along the way, but the ultimate outcome was that US had his appeal determined unfairly. Mr. Justice Ouseley so found, and the result was that his appeal determination was quashed. All of the subsequent things did fall away, and the original appeal was once more undetermined and had to be looked at again. In contrast, on the facts, they found that TN had not been treated unfairly, and so the appeal determination was not quashed in her case. But it didn't shut her out from relying on the new claim and the new material that she raised a year later. Mr. Justice Ouseley's own decision was that the Secretary of State did have to consider that as a fresh claim. So if the new decision were again a refusal of asylum, TN would have a new right of appeal to the FTT on this new claim. Totally unremarkable that those are the consequences that should follow from those factual findings. So I don't need to labour all of these points here. Can I then turn to the two points on which I need to respond? The first is the point about the relevance of the factors identified by the Court of Appeal in DA6. In her printed case, as we understand it, what TN says is that if any of those factors is present in an individual case, then that alone means that the appeal determination should be quashed. Learned friend Ms. Harrison in oral submissions yesterday, I think, was a little less clear about whether any single factor would on its own be enough. And of course, we do accept that in evaluating that single question of whether the claimant was treated fairly, any of the points in that claimant's case which fall within the DA6 factors are potentially relevant factors for the court to consider. But it's got to be looked at in the round. Indeed, if you look at what the Court of Appeal said at paragraphs 103 and 104 EF 212, they expressly say the JR court should be looking at these factors. So if learned friend Ms. Harrison is saying that actually, or not pressing the submission that any single factor will on its own be enough, then there is not a great deal of difference between the parties on that. There would, however, be serious problems with a decision that any single factor would be enough to constitute unfairness, as opposed to looking at them in the round. In DA6 itself, those factors, no single factor was enough to lead to the court's conclusion of systemic unfairness. it was a cumulative consideration of all of those factors that led to the conclusion that there was an unacceptable risk of unfairness. Without needing to turn it up now, can I give you the paragraph references for that? DA6 is Authorities Volume 1, Tab 5 at EF 2298. The Court of Appeal looked at the difficulties on one side of the coin, particularly at paragraphs 19 to 21, starting at EF 2305. It then looked at the safeguards that were pointed to by the respondents at paragraphs 31 to 36 at EF 2308. And then if you look at the court's discussion of all of that in the passage at paragraphs 37 to 45, starting at EF 2309, you see that no single factor led to the conclusion of a significant risk of unfairness. It was an overall evaluation of all of the factors involved. And so if TN is pressing an argument that any single factor, if present, will be enough to establish unfairness, that goes well beyond what the Court of Appeal did in DA6. The second point that we make as to why any single factor approach is wrong is that if any of the factors on its own is enough, then it's turning this into a checklist approach. And we respectfully say that the Court of Appeal in this case, and indeed consistently with what was in decided in DA6, the Court of Appeal in both cases was seeking to avoid any sort of checklist approach. And so it would be inconsistent with that. The third point is that logically, any single factor approach would actually reintroduce the issue 1 argument by the back door. These factors were discussed in DA6 precisely because they were common features of asylum appeals. For example, many asylum cases turn on credibility. They always have done, they probably always will. But in DA6, that was simply one of the factors that was involved in the conclusion that there was too high a level of risk of unfairness. If TN's argument, any single factor argument, is right, then it would mean that any one of these factors would automatically lead to unfairness and therefore quashing. And that is really just going back to issue 1, which by now ex hypothesi, this court would have rejected. The fourth point relates to the factor of new evidence or further evidence becoming available. We respectfully say that this does not automatically indicate that the original appeal was unfairly determined. There are two basic reasons for this. First of all, there will always be time limits in any form of litigation. Even in asylum cases, time will not be extended just in case some further evidence turns up. And even if the appeal is conducted under the principal rules, the evidence may turn up too late. There's no possible fairness complaint that could be made about the principal rules. And this just goes to show that just because further evidence comes after the appeal is determined, that does not automatically mean that the appeal was determined unfairly. And the other reason is this, that the absence of this new evidence from the original appeal may have had nothing whatsoever to do with the time limits imposed by the fast-track rules. It could have been a lack of diligence on the part of the legal representatives. It could be that the claimant simply didn't mention an aspect of their claim until a very late stage. Or there may have been a change in circumstances, the fault of nobody's, that allowed the evidence to come later when it could not have come earlier. None of that can be laid at the door of the fast-track rules. In fact, this is a point in which we refer to a causal link, or whether the unfairness was material. And so the mere absence from the earlier appeal determination of this further evidence doesn't mean that it was unfair. Ultimately, you can only assess this by looking at the circumstances of each individual case, and that is precisely the approach the Court of Appeal said should be adopted, and which we respectfully say was correct. And the final point on any single factor is that it is, we respectfully say, always instructive to look at what would have happened under the principal rules. It's an aspect of that first reason I've just mentioned, that there will always be time limits. There will always be a risk that evidence that an appellant wants will not be available in the appeal hearing, however fair the procedure is. There will always be the possibility that completely unobjectionable rules will mean that evidence is not available before. And if you look at it within that frame, you can see that that the impugned rules, the fast-track rules, may not have had anything to do with the unfairness. So that is the any single factor argument. The other argument that I need to deal with here relates to the presumption of unfairness. Our basic submission on this is that Mr. Justice Ousley and the Court of Appeal were correct to say that there is no presumption of unfairness here. But before one embarks on any argument about that, one of the first things that one has to do is to get the concept straight. And this was an argument which was a feature of Lumber and was dealt with by this court in Lumber. Can I ask to turn that up, please? It's Authorities, Volume 6, Tab 60, at EF 4208. The relevant paragraph is paragraph 42, which should be at EF 4232. The argument you'll see from the preceding couple of paragraphs was all about whether it was lawful for there to be for a policy to have a presumption of detention. And at 42, at the bottom of page 4232, Lord Dyson says, it is important at the outset to define clearly what a, quote, presumption, unquote, means in this context. It's the Secretary of State's case that paragraph 2 of Schedule 3 to the 1971 Act permits the operation of a policy in which she states that an FNP, foreign national prisoner, will normally be detained in certain prescribed circumstances. Such a policy serves as a guide to the caseworkers who make the decisions on the ground and as an indication to the FNPs of what they can normally expect in the circumstances specified in the policy. I shall refer to such a policy as, quote, normal practice, unquote. It need not, and usually does not say anything about the burden of proof. Normal practice is to be distinguished from presumptions in the strict sense. Phipson on evidence categorizes presumptions in this sense into rebuttable presumptions of law, irrebuttable presumptions of law, and rebuttable presumptions of fact. Such a presumption usually regulates the burden of proof in legal proceedings. Thus, a presumption that a deprivation of liberty is unlawful regulates the burden of proof in relation to that issue. The burden is on the detainer to show that there was a power to detain. I shall refer to a presumption in the strict sense as a legal presumption. And then the actual decision in Lumber was that the kind of presumption that was under challenge was a normal practice presumption. The court said there's nothing wrong with a policy that says normally you will be detained in these circumstances. This is normal practice. It was not a presumption of the kind talked about in Phipson that relates to legal proceedings. Now, we respectfully say that the first thing that is then apparent is that when TN's argument refers to a presumption of unfairness, it could not properly be what Lord Dyson describes as normal practice. That concept is completely irrelevant to the present situation. It couldn't be proper for the Judicial Review Court to find as or to adopt the normal practice of finding unfairness, except in specified circumstances. That's actually utterly inconsistent with the proper functioning of a judicial system. It would, in effect, be similar to asking the court to be biased in favour of finding unfairness. So that cannot be right. It cannot possibly be normal practice. So if there is any concept of a presumption involved here, TN could only properly be trying to invoke a presumption in the strict sense. That's to say, the sense is discussed in Phipson. But the problem with trying to impose that sort of approach on this case, or on this type of case, is that the question that the Court of Appeal was looking at is an evaluative question. That is what the court said at paragraph 97, EF 211. We draw attention to the fact that evaluation of this kind is done on public law issues, even when the claim itself is a private law claim for damages for false imprisonment. And the authority for that is JS Sudan. I just need to give you the reference. It's Authorities Volume 6, Tab 59, at EF 4189. The relevant paragraph is 45. You'll find that at EF 4202. So the evaluative exercise involved in trying to work out whether or not an appeal has been determined unfairly simply doesn't need to involve any form of presumption. It's not that kind of issue. But even if a presumption does apply, we draw attention to the fact that they usually regulate the burden of proof, as Lord Dyson says, and therefore they're actually only of importance in cases where there's no evidence on the issue to which the presumption relates. It's like the things that were taught at law school, that, you know, there's a lot of learning on burden of proof and standard of proof, but the cases are all cases that come out of the fact there was no evidence whatsoever, and it's only then that burden of proof and standard of proof make any difference. But in cases such as these, there will always be plenty of material from which the court can evaluate whether or not there was unfairness. So,
Mr. Tam, I think it's a question from Lord Stevens.
Well, I've been perhaps grateful for your views about this, approaching it on the basis that the person who is making the application for judicial review puts forward factual material before the court to arrive at a conclusion that there was unfairness. They're assisted in that by the fact that these are systemic rules that are inherently unfair, but they still have the obligation to bring to the court factual material, and the ordinary burdens apply in relation to that. So there's no presumption. They're assisted by the systemic failings, but they still have to prove their case, and so that's what do you say about that concept?
Well, Lord, I'd gratefully adopt that. That is exactly the situation that we say we have in this type of case. First of all, at a very basic level, if the claimant says my appeal was determined unfairly, then they will know why it is that they consider that it was unfair. All the matters that they rely on will be known to them. we make the point that some of those matters may be within their exclusive knowledge. The Secretary of State may know nothing about them whatsoever. So as a matter of practicality, as my Lord says, the claimant is able to bring those matters before the court. And as the person asserting that there are such matters, it is unremarkable and utterly conventional that the person has the burden of bringing that material before the court. Once the court has material like that, the question of any presumption just simply falls away because there is material. Presumption is only important where there is no material and no evidence on the question concerned. I accept my Lord's point that obviously the evaluation of fairness will have to be done in the context of the rules, the time limits imposed by them, and that will be the context in which the court says, well, this was fair because it didn't affect anything, or it was unfair because actually the claimant needed more time to do X, Y, or Z. That is part of the framework. But the question of presumption, we respectfully say, just doesn't enter into this at all. Partly because it's an evaluative exercise with no burden of proof, and partly because even if that's wrong, there is material, and the presumption, the notion of the presumption, just immediately becomes immaterial to the exercise.
Thank you.
I should point out that both Mr. Justice Ouseley and the Court of Appeal were careful to say that they were not placing a burden on onto the claimant to show unfairness. The references for that are Mr. Justice Ouseley, paragraph 114 at EF 255, and the Court of Appeal, paragraphs 97 to 99, starting at EF 211. I don't seek to dispute that. Obviously, there is a burden in the sense of perhaps an evidential burden if one were to analyse it in the legal concepts, because the claimant has a case to bring, and one would expect the claimant to bring it. But in the evaluative exercise, if you consider that both Mr. Justice Ouseley and the Court of Appeal were correct, there is no burden as such, and we don't seek to gainsay that. And the final point on this is that if the claimant wishes, as part of their argument, to highlight those aspects of their case which are factors mentioned in DA6, then they are free to do so. No presumption is necessary to allow them to do that. And the Court of Appeal itself, at paragraphs 103 to 104, EF 212, says that the court should look at these factors. So the idea of a presumption, we respectfully say, is utterly unnecessary and indeed legally flawed, and therefore we would invite the court to reject that argument. Now, my lords, I've got myself into a tricky timing situation because those are the end. That's the end of my submissions on issue 2. I have some relatively brief submissions on issue 3 to make, and it might be a bit disjointed if I were to start them now just for a few minutes. So I wonder if this might, although a few minutes early, be a convenient moment.
I'm sure it would be a convenient moment, Mr. Tam. Thank you very much. We'll resume at 2 o'clock.
Very grateful.
Thank you very much.